How to rescind your mortgage legally without court. Part 4. Steps to rescind and cancel a mortgage. You now understand that rescission is not only possible, it is legally enforceable when fraud is present. However, rescinding a mortgage is not a process you can rush or attempt without the necessary foundational knowledge. You must approach this with discipline, precision, and a strong command of the underlying legal mechanisms. Your first step is to reject the notion that foreclosure is the only outcome for financial distress. The Truth in Lending Act, TILA, grants you the right to rescind a mortgage under specific conditions, particularly when there is a material failure to disclose critical information during loan origination. This right was confirmed by the United States Supreme Court in Jesinoski v. Countrywide, which established that a borrower can rescind a mortgage merely by sending written notice, not by filing a lawsuit. You are not required to default on your loan to exercise your right to rescind. That misconception is harmful and legally incorrect. The rescission itself nullifies the contract, thereby eliminating the alleged default. The law does not punish you for exercising your rights, it punishes lenders who violate disclosure laws. You must understand that the mortgage is the security agreement, not the promissory note. Many borrowers incorrectly focus on the promissory note when attempting to rescind, failing to recognize that it is the mortgage agreement, as the collateral instrument, that must be targeted. The note may be unenforceable due to fraud, but rescission applies to the mortgage agreement under federal regulation. You also must understand that your signature is the funding source. According to UCC Section 8-102, your signature creates the entitlement to the instrument. That signature alone is sufficient to trigger rescission rights when fraud is present. If you bypass the earlier lessons and skip to this step without understanding the structure of mortgage fraud, your attempt to rescind may be rejected or ignored. Therefore, you are strongly advised to master the full process outlined in this report before initiating any legal correspondence with your lender. Rescission is not a loophole, it is a statutory right. When you exercise that right correctly, with lawful intent and supporting documentation, the lender is obligated to act. If they do not respond within 20 days, they are in violation of federal law and liable for statutory damages under 15 U.S.C. Section 1640. Footnote: this section outlines the precise legal and procedural steps required to properly rescind a mortgage under federal law when material disclosure violations or fraud are present.